I will proceed in this manner. If the witness was the record keeper, the document comes in without prejudice to the defense making submissions at the right moment as to what the prosecution seeks to do in terms of proving their case with each particular document.
Yes, I'm just a little unclear about that last bit. Without prejudice to the defence making submissions at the right moment. Now, when is that right moment?
The right moment could be at the point where the prosecution says, judges, document X, which the witness, the CPEV clerk said was his, was admitted, and document X says that, and we want you to convict Mr. Ruto or Mr. Sang on the basis of that assertion. That would be the right moment.
All right. Now, that right moment can either come, as we'd hope it would, on Your Honour's or the Chamber's direction to the prosecution to produce a table forthwith, identifying those aspects of these documents that they rely on so that we can respond. Because the alternative is that we then have to, wait, let's say in theory to, say, closing briefs. Well, closing briefs, of course, if the other cases in this court, as happened in Katanga, where we had simultaneous filings, prosecution and defence, we'd have no opportunity to put in a written objections. And these kinds of issues are not well treated or suitable, really, to oral submissions made in the course of, for example, final submissions. And so the right time would be a right opportunity, and I'd ask the court to give us that opportunity, and that should be more or less forthwith. These are the documents. This is what the prosecution seek to have for the purpose for which it's being admitted, and here's the defence decision. Here are the defence arguments as to why, for example, there is not sufficient indicia of authenticity, which is one issue that still has to be addressed, whether or not there's a connection with this witness, and secondly, whether it's appropriate in the circumstances that documents, for example, that rely on hearsay and anonymous sources and reports that have been rejected already by the Chamber, etc., etc., etc. Quite a matrix of objection that arises because of the nature of these documents.
Mr. Hooper, we are comfortable that you can deal with this matter at the right moment. However, the Chamber defines the right moment, either at the point of submissions, final submissions in the case, or if you do make your no-case submission at that stage. So let's not belabor the point. We'll proceed as outlined.
Well, we'd feel prejudiced by that, and we'd seek, in those circumstances, to address the documents through the witness, if that's the only alternative we have. We need to make submissions about admissibility. We wouldn't want what I thought was a practical approach to this morning's witness to end up prejudicing our position. If the prosecution want to laboriously go through this material, then so be it, because we have issues, of course, as to the provenance of this material that we could raise. We've shortcutted that to some respects. I hope it's not going to prove to our prejudice.
Your point is noted on the record. Yeah. Let's proceed.
With your permission, Mr. President. Mr. President, I had inquired if it is possible for us to be allowed to cross-examine prior to the attempt to produce the documents, and I was wondering whether you could...
You will have your opportunity to cross-examine a witness. We're not going to do it in the middle of the prosecution's examination in chief. Thank you.
Thank you, Mr. President. I'd like to proceed by showing you a document, and I'll I'll ask the court officer to pull it up on the screen of the witness, but the document is confidential and the blinds should be down for that purpose. Meanwhile, the ERN number for this document is KenOTP 0001 1288 under tab 3 of the OTP bundle. Witness, could you see the document displayed?
I can see the document displayed.
Again, why are the blinds down so that 1288 being discussed?
The prosecution considered this document to be confidential in nature because it was presented to CPEV, our understanding, in private hearings, and is a confidential document from CPEV, has not been publicly distributed. It contains names of witnesses, their addresses, their phone numbers, the summary of their evidence, etc. We do not intend to bring those sections to the attention of the witness. However, the nature of and the existence of this specific document is confidential. Witness, have you had the time to look at the document?
Yes, I've had time to look at the document.
Have you seen this document before?
Yes, I saw this document.
Could you please explain the circumstances in which you saw this document before?
This was among the documents kept by the assisting counsel.
Kept where?
In his office.
And how did you see, or how did he come to see this document specifically?
This copy, one copy was produced to the commission, and I had to reproduce three more copies one for the assisting counsel and the other for the two commissioners for their use.
You said the document was produced to the commissioners, to the commission.
Yes.
Sorry. Could you please explain what you mean by produced to the commission?
This document was tendered in as an exhibit in a private session in the early days of the commission.
Do you know how the document was tendered as an exhibit?
This document was tendered in private, and if I'm not certain, it was tendered by Muthoni Wanyeki. She produced the report in private. If I can go by the list of exhibits that are hard to generate after these documents had been produced in private.
Would you be able to provide the spelling of the name of the person or witness through whom the document was tendered, because the transcript could not capture it?
Muthoni Wanyeki, MUNOKI WANYEKI.
And who was that witness?
She was from Kenya Human Rights Commission.
What did you do with this document after you made copies for the commissioners?
I returned them to the assisting counsel. All the copies made for distribution to the other commissioners.
Do you know what the assisting counsel did with the document after you returned it?
I don't know.
Mr. President, if I may tender this document into evidence, I can provide a specific paragraphs or pages upon which the prosecution intends to rely upon. I can do it at this point. I can do it at the end, as your honors direct me to proceed.
Can you note that now onto the record, and then at the earliest opportunity give the defense a comprehensive list of the parts of all the other documents you are tendering that you're intending to rely on? I mean, the lists of those parts of those documents you intend to rely on. Okay.
I can certainly do that. For this document, the specific pages we intend to rely upon are Ken OTP 1296 1302 and then pages 1397 to 1423. Plus the first page, 0001, 1288. Up until 0001, 1295. And 1296. Up until 1304.
Just one matter. Is there any reason why the defence hasn't been provided with these pages or other references before this morning? We've had no opportunity to turn up these pages and discuss their relevance and our objections to them. The court's going to, of course, need now to look at each document, document by document, before any question of admission arises. You're going to have to listen to objections. The Bemba appeal and all that.
So you, hold on, Mr. Of course, appeal is always part of the legal process. Lawyers who don't like the ruling of a court can always appeal.
No, I'm not seeking in any way to be confrontational.
No, it's not that.
The Bemba case, which you quoted yourself, in your paragraph 19 of your decision says, mindful of the appeal chamber's ruling In the Bemba appeals judgment, the Chamber conducts its admissibility assessment for each item individually, undertaking an item-by-item analysis, providing individual reasoning. And that's the process that we appear to be entering into now in an oral forum. But we're disadvantaged because the prosecution has chosen not to provide us with any indication of those parts of these documents that they're seeking this morning to rely on.
Right, your concern is noted. Ms. Dago, do you have any response?
Yes, I do. The prosecution did not provide the sections to the defense because this document contained a table of contents, and it's quite clear that the section concerning the charges in this case is clearly indicated at page 4. It has a chapter titled Eldoret, and I don't see any ambiguity in that section. In addition, the table of content itemized the sections and the pages per topic, obviously, the general part, and then it descends into the analysis of each one of the provinces and areas affected by the post-election violence generally in Kenya. However, I repeat, the part from Eldoret and the Rift Valley is clearly indicated in a table of contents. We did not do it with the intention to deceive the defense. We thought it was straightforward and clear on this document.
Right. Yes, well, thank you. You can see how very different we viewed things, because I assumed that the portion on Eldoret would be the one part that would be omitted, because it deals with anonymous sources and the like, and of course with the substance of the case. And as we've seen in your decision recently, that's an inappropriate area in your view, and we respectfully agree, for the court to be looking at material of that kind. In terms of background material, what else was going on in Kenya, for example, elsewhere, we could see that there'd be some perhaps interest on the part of the Chamber in respect of this kind of material, as it's already expressed its interest in terms of background material. But here we've got the prosecution, as we'll see. I'm not making arguments now. I'll come to that in due course when this process is finished. But the prosecution here are seeking to introduce exactly an area and kind of evidence which the court has already said it is not willing to accept.
Mr. Keegan-Katwa?
Yes, Mr. President. Well, we support these views. In addition, I'm actually confused because there are a number of references that we're particularly concerned with in this document. And I just want to ask clarification on your part. Firstly, are we, when the prosecution seeks to rely on certain pages, are you limited to that? Or is somehow, because in your decision you say you prefer the entire document to come in. So I just want to make sure that if you're relying on the references of the prosecution, that other references are not of our concern anymore. That's my one question for clarification. And then I just want to make sure, because there's 2-page numbers, and I think they're excluded, but I'd like to be sure, because these are of particular concern to us, which is 1342 and 1354. There are some other references in the documents that the prosecution seeks to rely on that we have a particular objection to, which I can raise right now or at a later stage.
You asked for clarification. I see why you asked that in the we call it colloquially, the bar table decision, we had rejected some documents that were either not eligible or that had missing pages. And you're trying to wonder what's going on now that the prosecution has also indicated certain pages. There is no inconsistency. The thing is this. The prosecution has now indicated the pages that it wants to rely on this document. The document has other pages. At least we know that the document is complete. Perhaps in those other pages, the opposing party might see something of interest to them. They also may be relying on. The fact that the prosecution has indicated the pages that the prosecution is interested in this document does not preclude the defense from relying on the other pages that the prosecution has not indicated. But the defense or the opposing party is in a difficult position with a document that is not complete because you do not know whether there are other pages that contain stuff of interest to you. That was why we said we would not accept the documents that had missing pages in the past.
Mr. President, if I may. Because as I understand it, we can still rely on the other parts, but what about you, the judges? The only reason I really want to be sure is because there are some incriminatory parts in these parts that I think the prosecution is now not seeking to rely on. So should we not be concerned at all, or do we actually have to make observations on these, whether it's now or in our half-time submissions?
I think it's better to deal with that in your half-time submissions so we can move on.
One more thing, because we have some observations to, on the actual pages that the prosecution is relying on. Should I make these observations now? There are some, I can refer you to page 1406, 1418, and 1400. And these are references to our client or KSFM. And we have a difficulty admitting this document in this way. I just rely on your decision. I note you make a distinction between the bar table and admitting this document through a witness. However, there are some certain principles that you've set out that I think are very important in considering the admissibility of this document. In particularly, paragraph 14, and this is 1353, the bar table decision, you make reference to your overarching obligation under Article 64(2) of the statute to ensure that the trial is fair and expeditious, and with full respect for the rights of the accused and due regard for the protection of victims and witnesses. And on that basis, you state that the chamber may rule on the relevance or admissibility of any evidence, taking into account the probative value of the evidence and any prejudice that such evidence may cause to a fair trial, or to the fair evaluation of the testimony of a witness. And to come back to paragraph 25, where you do note that there's an obvious interest on the part of an accused person to confront any person whose testimony would implicate an accused in criminal conduct, either directly or indirectly, including for purposes of the theory of common criminal purpose. And then you rely on Article 67(1)(e) and 69(2), and also Rule 68. So in light of these observations, I would like to take you to these particular paragraphs that we have a difficulty with. To start off with 1406.
Yes.
This is clearly, you see in the middle, if you have the page in front of you, there is a submission of someone. I will not say the name in public, but this is clearly testimonial. There is a reference here to KSFM, which is directly important for us. And this is a testimonial statement that is now sought to be introduced in this manner. Well, you've indicated yourself that Rule 68 should not be circumvented. And, well, there's none of the, I don't think I have to take you through Rule 68, because this is clearly not compliant with Rule 68. Then I would like to take you to the next one, which is 1418. Which is even of more concern. I see my learned colleague is standing up.
Apologize, I didn't mean to interrupt. However, I should like to point out that the prosecution has not had the opportunity to make its submission on the purposes of tendering this document. Therefore, I believe that we're jumping the gun, if I may use this colloquial expression, and because we're descending into discussions of testimonial evidence, whether the testimonial evidence is relied upon to prove in support of acts of conduct of the accused, rather than background information. So I believe that to canvass this discussion in a more meaningful manner for the defense as well, is that the prosecution is allowed to make its own submission as to why the prosecution wants to rely upon this document. Thank you.
You will, in the circumstances, get a privilege of reply, but let Ms. Persman finish her submissions.
Thank you, Mr. President. At page 1418, a reference is made to CASFM, and there is a quote, which is directly incriminatory to Mr. Sang. And then underneath it, there's even a reference to Mr. Sang himself. We don't know who made this allegation. It's anonymous. It's based on the Kenyan National Commission of Human Rights. We know that that's one of the reports that you have excluded in your decision on the bar table motion. The other statement just above it is again testimonial. We have a name. I won't say it in public, but we have no other information. We do not know how this allegation came about. And there's one more that I wanted to bring to your attention, which is on page 1400. Which is again a direct reference to CASFM in a statement that is testimonial. We have the same problem with this one as we had with the others. So these are the specific references that I would like to point out. We do not think this should be introduced in this manner. And of course, in addition, we have more general observations that the whole report is based on double hearsay, on reports, on other reports, some of which have been excluded by you, the judges. It's an incomplete document. There's often there are dates missing. There's names. There's no methodology that's really spelled out. So these are more general concerns that we have with this document.
Can you speak to the extent possible on those general concerns? So you now have the floor. Can you address them?
Yes, Mr. President. I have to admit, this is on the assumption that the entire document was to be admitted. So, for instance, we have a problem with certain conclusions in addition to the ones made in relation to my client. But there is, for instance, at page 1422, which I believe is still part of the document I seek to introduce, there is a reference to the violence was both pre-planned and spontaneous. It's again a determination that should be made by you, the judges, and not on the basis of a document, particularly if the makers of the statements are not before you. And just, okay. There's some other, well, there's a lot of testimonial parts. I can refer you to page 1397 to 1418. And there's others like 1492 to 1513. These are all testimonies of witnesses who are not in front of you. And we do not have the names of the takers of the statement. We just have a summary of what these witnesses have testified to.
Would it be correct to summarize my understanding of your position to be that you are objecting to the parts of this document that contain testimonial information as well as conclusions as to the guilt of your client?
That's correct, Your Honor. In sum, our submission is that the prejudicial effect of even the parts of the documents they seek to tender by far outweigh the probative value of this document. That is our submission, Mr. President.
Thank you, Your Honor.
Yes, if the defence are having allowed to make some observations, then we certainly have some observations to make in respect of the document. I bear in mind what my friend said about she hasn't yet addressed the relevance or the sought relevance of this particular material. But you've got the document at, I think it's your page 3, is it? Your tab 3. Is it tab 3? Because we've had different nominations of these matters, and it is tab 3. Now, the CIPEV report. This isn't the CIPEV report. This is the gender-based report, and the first section that my friends referred to is 1296 to 1302, and later 1286 to 1295. So we're dealing with, as I understand it, the very first part, that is from the forward onwards, the introduction, and it first of all states at paragraph 9, oh, I'm sorry, let's go just before that, indeed, right from the beginning, from 1296. The background information upon which the report was based. And you'll see straight away it's got NGO reports. The next is media sources. That's itemized at page 9. And then United Nations reports. And in particular, the United Nations High Commissioner for Human Rights, the OHCHR, that was present, as the court knows, in the country in February. And then we've got the KNCHR report, to which this investigation team had some access, limited access, to their database. And then it deals with police reports. And we see that now it's beginning to, of course, make findings or make statements of fact that go to core issues in the case, in which, as my friend Ms. Busman has already said, the court has already resigned from relying on as a usurping of function, judicial function. At page 12, for example, you have under the heading factors considered to have contributed to the PEV, and then it lists various things. Now, of course, as far as the various reports, UN reports, the Human Rights Watch reports that refer to and which are a foundation basis for this report, this court has already rejected those reports as being inadmissible due to anonymity of sources, lack of clear methodology, and also because some aspects of it touch on core issues. So in your decision, you've already rejected these reports, and yet here is the substance of them being, as it were, allowed in or sought to be allowed in through a back door in the wooden horse, as it were, of another report. And we see, for example, that the under factors considered to have contributed has allegations of rigging, politicians telling their opponents we're planning to rig the elections, ethnic tension, use of criminal gangs there, Mungiki, the Taliban, and the Chinkororo, things we've never heard of in terms of the Chinkororo. I've never heard of them. The Taliban, the Kikuyu gang, I understand. Goes on in this way. Now, this is obviously grafted onto this report from various unspecified sources, because they only give a general indication of the grounding documents they've looked at. Documents, as I say, which have been rejected by this court in its decision. And then there's a province-by-province view. Now, Eldoret, and this is at page 108, 1397, sought to be relied on by the prosecution. Paragraphs, they told us, pages 1397 on the KenyaMOJA.com designation. That's 1397 to 1423. If we look at that, we see that that is all the Eldoret matters up to 1423. Then we move on to Nyanza province, not relied on by the prosecution, we're told, at page 135. So, for ease, we're dealing with page 108 to page 135 of this report, relied on by the prosecution. And if you look at that, you'll see that we're dealing here with about 30 witnesses or persons who it has been purported investigators relating to this gender-based inquiry had resourced to. That's not clear. The methodology isn't clear. We don't know if it was their particular investigators interviewing or whether it was as a result of access to, for example, the KNCHR database. And one can see that in these witnesses, all totally testimonial, we can see at page 111, dealing with issues central to this case. Dealing there with CAS FM. Then we have, because it's a gender-based document, a number of witnesses relating to rape. We've had no evidence of rape in this case. Whole new issue. And then from page 118, it moves from being nominated, not anonymized, but nominated persons of whom, of course, the defence does not have access because we don't have sufficient detail about them. And in any event, this has been sprung on us this morning. From page 118, we have a review of statements and information collected. And again, it's not set out what, in fact, that is based on, what statements or what information, which are the reports. And you see that there's then a series of factual comments that is being sought to be admitted in considerable detail, evidential, quite clearly, dealing even at page 129 with evidence of inciting, names of alleged perpetrators, including Mr. Sang and Mr. Ruto, and others, part of the names that are featured in network allegations. And again, we can see based there at page 131 on the KNCHR report, and you know the extent to which that is a contentious report, because it suggested that there were corrupted witnesses who were providing a corrupted story. All of this repeated. And at page 133, as it's been already commented upon, findings, core finding, once again evidence of both pre-planned and spontaneous violence, contingency planning on the part of ODM supporters. And then we move on to Nyanza. As I understand it, though I've done so briefly, I've dealt with all the pages, or have specified all the pages that the prosecution rely on. My friend will correct me if I'm wrong. And this witness, in any event, in his statement at paragraph 247 said, "I cannot remember now who authored or provided this document. I think this is one of the reports received by the Commission."
Are you talking about the witness now understand?
Yes.
But the witness seems to be fairly certain in his testimony.
Yes, well, I'm signalling that up. I'm looking at his paragraph 247 of his statement.
My question to the defense counsel, Mr. Hooper, you can take it first while you're on the stand. And the prosecution would also address it when you do speak. Apart from testimonial material or conclusion as to the core issues in the case that we are trying, is there nothing left of this report for purposes of context, background information on the post-election violence?
Well, maybe indicated earlier.
For the purposes of possibly counsel saying as long as the document isn't being used or relied on for purposes of this other stuff, we can live with it.
Well, the background material is perhaps, if anywhere, found in the other sections dealing with Nairobi and dealing with the other provinces.
There's the matter of sexual violence, for instance.
Yes.
Take that for example.
We'll
Is it not of interest for purposes of what happened to say, if that's the case, that sexual violence was also committed?
Well, it's not an issue. Has there been a witness that the prosecution have produced in relation to sexual violence so far? Has there been? Why is it being brought in this way? Why can't the defence have the opportunity of confronting people making such allegations? Because it does have an extra dimension to it, and we well know this court's attitude towards gender-based crime. So it's something that should be, if it's going to be produced to the court at all, it should be produced in the ordinary way. And a general allegation, these aren't general allegations, these are quite specific positions that are made in the course of those statements.
But there's a difference, isn't there, between saying, as part of the post-election violence, there was gender violence. There's a difference between that proposition and going the further step of saying, and it was your client, Mr. Hooper, or your client, Mr. Keegan-Cartwell, that who are responsible for it.
Yes, but it's not. I'm reminded, it's not even charged. But aside from that, we've had no evidence of it. There's no way in which the defence have been able so far to address it. We'll be left in the position of an allegation hanging in the air with the only possible response the defence can make to it by calling witnesses. But to prove a negative, it'd be quite difficult.
You need to prove the negative if it isn't necessarily no allegation that your client committed it.
Well, it depends who's committing these offences. Is it the gang, part of the network gangs that we're said to be controlling? Is it they who are committing these offences? There's the problem. It's all part of the. It's more than just context and background, isn't it? It becomes a highly prejudicial element.
This inquiry, the purpose of it, on my part, is there have been witnesses who came and testified that they were subjected to violence, and you did not dispute that they were subjected to violence. Your point was that they had not said that your client was the one who did it. Why is that different from the question of sexual violence?
Well, it's not been an issue. We haven't investigated it. We haven't looked at the sources of this material. May I say also, as a general matter here, none of these, even where they're nominated persons, none of these statements are annexed to the statement. So we've not had access to any of that material. As a general proposition that during the post-election violence there were crimes of a sexual nature, I don't think this defence would seek to stand in the way. As a general proposition on a national basis, where it comes into Yiz and Gishu, where it comes into sight of our case, then we would submit it's wholly inappropriate for the prosecution to raise this particular issue, uncharged as it is, in this way. And those are my submissions in respect of that. Can I just say that there are specific prosecution witness statements, witnesses in this case, P189 and P15, to whom reference is made here by way of statements they're alleged to have made. So it even goes that far. in this case.
Right, Mr. Hooper, one more minute.
Yes, certainly. We've dealt with a very particular problem, and that is the United Nations and the Human Rights Watch reports. You've rejected those. You can't, in our submission, allow them back in at this stage, and yet they've infected the entire report here. This report was not, of course, intended for the purpose of use in a criminal trial. It's another matter. It's presented, there's a disclaimer at the end page, as you can see.
Where is that? Where is that?
Right at the end.
What page?
Page 20, mine's got page 23 on it. I'm not sure if that's the very last page. If you turn to the very last page of this section, right at the very end, under the name of Melinda Ricks, CIPEV investigator. Not someone, of course, who's ever been sought by the prosecution to produce. And we see note references. It reads, "This report, as it is presented, is intended for the internal consideration by the Commission of Inquiry into post-election violence. References in this report include some names and initials of witnesses and victims whose evidence was not given in public and which are to be kept confidential within CIPEV."
But I was interested in the part where you said that the report was not intended for use in court.
That's plain from that disclaimer.
So that was your interpretation?
That's my interpretation, yes. Yes, that it's for internal consideration by that commission.
Your 1 minute is up, Mr.
That's it. Well, that's it. But you can see the difficulties as we approach 1:45 that the prosecution have placed us in, and you, the judges, in really, by approaching this in the manner that they have. We don't have references, the future references that might be relied on, or the reasoning behind it that hasn't been furnished on us. I don't know what we can get by the next time we sit this afternoon, but you know, it's rather woeful.
We will go until 1 p.m. When we will rise for our lunch break. Until then, Ms. Saigo can address the concerns raised by the defense. Witness, all this I'm sure is nothing strange to you, so bear with us while we sort out all these things. Thank you.
Mr. President, I was wondering, since we started here, could I have 1 minute to
Ms. Osman, I think you've said enough. Let's hear from the prosecution for now.
Thank you, Mr. President. I'd like to take address the last comment by Mr. Hooper. I believe that the gender, this document, for clarification, this document, the first page, 0001-1288, the cover page, indicates that this report contains 2 sections. One is the investigation section final report, and the second section is gender-based violence report. The prosecution, when provided the relevant sections it intended to rely upon, did not include the gender violence section, which starts, if I'm not mistaken, at page 1491 onwards. But aside from that, I wanted to clarify that the prosecution intends to rely upon this document for background purposes. In particular, in those sections mentioned, there is a description of the general methodology and information that the CIPEV and the investigation section relied upon, explicitly referring to NGO reports. It mentions certain sources of individuals that have been interviewed by the investigation section during the period of the investigation. It also, for background purposes, relates to factors considered to have contributed to the post-election violence and the allegations of rigging elections, ethnic tensions in general that we have heard from other witnesses in this case. And this in particular...
Let me stop you, please. Not stop you, but interject. You're saying you're not seeking to tender this document for the gender-based violence story.
That is correct, Your Honor.
Continue.
In terms of the criteria that the Chamber has clearly identified in their 10 June bar table motion, prima facie relevancy is determined by the relevance of the subject matter contained in the report or in the document which it is at stake. In this case, we submit that there is indeed a connection between the content of the document and the matters and issues at stake before the Chamber. And in terms of the indicia of reliability, which is the second portion or the second pillar of the analysis in terms of relevancy or prima facie relevance, is, as Your Honors have indicated for other documents of a similar nature. In particular, I refer to the European Union final report on the 2007 elections, refer in Your Honors' decision at paragraph 39, which acknowledge that the document, the report, the European Union report, provided limited information on the content and the modality in which the information was collected, but found that it was prima facie relevant because it provided background information to the charges and was potentially supported by other evidence, including testimonial evidence. And the prosecution submits that in the case of this document, we have heard witnesses referring to the prevailing tension between political parties in the pre-election period. We have heard witnesses providing information about ethnic tensions between the communities in particular areas. We have heard the interpretation given to the word Majimbo, for instance, which is another element that is addressed in admitting one of the documents in the bar table motion decision. Additionally, this document or this report identifies to a certain extent the methodology used by the investigators. It identifies some of the sources, including by name, including witnesses with their names and addresses, which other reports that have been admitted by this chamber did not include. Therefore, we argue that this document, in contrast to other documents already admitted, has more indicia of reliability, has identified and listed by Your Honors, than other documents. And I'd like to underline the fact that the purpose of this submission or this application is to admit this document for background purposes. Therefore, the prejudice to the accused and the defense is certainly lower than if we were to intend to and seek to rely upon this document for the charges against the accused in this case. The document also is corroborative of other information that we have heard in this case, and the other information that is contained in other reports that were admitted by your chambers in their recent decision. Therefore, for all these reasons, we believe that the indicia of minimum indicia of reliability, and in general, the assessment on the probative value for this document have been met, and this document should be admitted. Thank you.
What does this document add by way of background information that you say you are seeking to admit it for? That testimony of witnesses heard so far do not supply.
It provides more detailed information about the general background in Kenya about the post-election violence. Against that backdrop, the violence in the Rift Valley and in the areas that we have charged are more clearly canvassed and extensively explained.
Have you tendered the CPEV report itself, the bigger one?
Not yet, Your Honors.
Will you be seeking to tender it?
I believe so. I should be more assertive, yes. Not through this witness.
Why not through this witness?
Because as far as our understanding goes, the witness did not participate in the drafting of the final report itself. Another witness who is anticipated to come who has taken direct participation in the drafting process will be more in a position to provide information about the CPEV final report.
Would it be McFadden?
That is correct, Your Honor.
Would there be a duplication between the background information provided here and the background information that Mr. McFadden will be speaking to, or even in the larger CPEV report?
The larger CPEV report, without testifying myself, I believe includes also evidence that was heard during the hearings conducted by the Commission, which is not included in the document that we are analyzing at this point. This document only is a collection of information that the investigation section put together. The final report by CPEV is based on findings, also based on witnesses who testified before the Commission, which is not included in this report.
The CPEV report is a public document, isn't it?
It is.
Do I take it that it does not list witnesses who give information by name and what they said?
I believe it doesn't list names of witnesses.
What I'm driving at here is how much do we need to establish background information? If we've had witnesses who've testified to some of that, or who've given information about background events, including expert witnesses and or the expert witness and other factual witnesses, and we are expecting Mr. McFadden to come say, also give information about background information? Are we going at some point to overload the circuit with background information?
Your Honors, the reasons why we sought to introduce this document is specifically because it provided more information on the underlying material and explanations of how the evidence from CPEV was collected.
We have run out of tape apparently, so let's take a break now and come back.
Thank you, Your Honor.
All rise. We will wait.